looks like most of us are here, so I am going to go ahead and start this. This is the B-Quiz statewide training for decision making and guardianship. Jessica Harlan York is not able to join us today, but she is the Chief Operations Officer for BEADS. Heather Dane is with us today. She's the Chief Program Officer for BEADS. And our guest presenter is Melissa Key. She's the Executive Director at Indiana Disability Rights. And I am Jennifer Akers. I'm the Training and Engagement Specialist at Liberty for BEADS. Please use the chat for immediate technical issues, or if you want to say hi, that's fine. It goes primarily to the hosts and the panelists. If you've got questions, please put them in the Q&A button. We're going to hold those till the end to make sure that we get through the presentation. We've got about a half hour dedicated at the end for Q&A. So either Heather will answer it directly if she can, or it may be something that we wait until the end so that we can ask Melissa for her expertise. If it's really personal and specific, it might be something that we need to follow up with, because this is a public recording that will go on YouTube. So if it's a very specific question unique to an individual, we may need to follow up with you, but feel free to put your questions in the Q&A as you think about them so that you don't forget, but we'll answer them either live in the Q&A box or at the end. If you want to use the closed captioning, just click that in order to see the live transcript. It should allow you to turn that off also if it's problematic to have that running at the bottom. And you will get an evaluation with a follow-up email from Zoom. If you could complete that, we'd really appreciate it. It helps us know how to improve these. It also has a chance for you to ask for things that would be of interest to you. We do have a schedule for this fiscal year, but it can help us prioritize the order of those. I'll share that information at the end so that you know when the next training will be. And this recording will be uploaded to the BEADS B-Quiz YouTube channel after the live sessions have been conducted. So we have 3 sessions this month, so I would anticipate that it would go to the YouTube B-Quiz channel, which will now be called BEADS channel as of July 1st. You may have noticed those changes in the housekeeping slide, but it will be uploaded there and you can look at it. That information will go out in a DDARS announcement when it's available. So look for that probably the beginning of August. Heather, are there any questions that need to be addressed before I move on?
No, ma'am.
All right. Some of you already know this about me, but I'm the mom of a child with multiple disabilities. Grace was born with Mobius and Pierre-Robin syndromes, and she struggled to breathe the minute she was born and was rushed to the Children's Hospital. She almost died there more than once. She had multiple surgeries to keep her alive, and it was not the motherhood that I had imagined. She stayed there for 4 months before I got to bring her home, and she came home with some extra accessories, a G-tube, a trach, and a ventilator. We were fortunate enough to get the aged and disabled waiver and later the CIH, so that meant I had help caring for her in our home. We had nurses, therapists, specialists, and more in our lives now. And as a new mom, it's hard to know who to listen to. They don't always agree. You realize that even professionals don't know everything. And you discover that you're in a mama bear. Your child has struggled more than she should, and all you want to do is make life easier for her. But if you're lucky, those new people in your child's life care about her almost as much as you do. They want her to be successful, to thrive, and to be the best that she can be. Your nurse suggests putting your child on a horse at age 4, and you trust her enough to try it, and your child loves it and thrives in her development as a result. You send her to school, knowing she'll struggle more than most, but knowing that she'll grow too. She'll develop friendships and relationships that enrich her life. And you trust her speech therapist enough to let her try a therapy session in the pool, and your child who once struggled to breathe is floating on water and enjoying every minute of it. I'm sharing all of this because we're going to talk about decision-making and guardianship today, and I want you to know that I understand that guardians' directives typically come from a place of love, a desire to protect their child, to not let one more bad thing happen in their life, and to even avoid failure and disappointment, which isn't realistic, but still our hope. I also know that a parent's worst fear is what happens when I'm gone. One of the best ways to plan for that is to support decision-making for an individual, to identify decisions they can make themselves, when they feel they need support, and when they need a trusted advisor. This means they'll have a village of people supporting them and empowering them to live their good life. Supported decision-making is just a fancy way of describing how we all make choices. We all need help making decisions every single day. Think about it. When the doctor says you have a somatic injury or a brachial obstruction or something else that sounds like a foreign language, what do? When you don't know the difference between itemized and standard deductions, how can you file your tax return? When the mechanic says your car has a blown head gasket, how do you know whether to pay for repairs or not? You probably ask a friend or a family member what to do, or if they know someone who can help you cut through the jargon so you can understand what's going on and what you need to do. It's just common sense, right? When you don't know enough to make a good decision, you find people who can help you. It could be going to your brother, the accountant, with tax questions, or talking to your friend, the nurse, when you need medical information. When you do that, you're using supported decision-making. You're getting the help you need and want so that you can make the decisions you have to make. Melissa's going to explain this in more detail, but I wanted you to know that there are tools to help guide these discussions with guardians and individuals, like the life course tool that's on the slide. We're talking about this topic because it was the #1 discussion item when we conducted the Quality On-Site Provider Review, or COPR, which are still happening, but we've been doing them since September. Those discussions help the state ensure that individuals are receiving quality, person-centered services that empower them to live their best lives. So let's take a minute to review the goals of Indiana's home and community-based services, or waivers. The goals of waiver services are to provide the individual with meaningful and necessary services and supports, to respect the individual's personal beliefs and customs, and to ensure that services are cost-effective. Specifically, waivers for individuals with an intellectual or developmental disability assist an individual to become integrated into the community where he or she lives and works, to develop social relationships within the person's home and work communities, to develop skills to make decisions about how and where the individual wants to live and other decisions in their life, and to be as independent as possible. While a person's eligibility might correspond to a particular level of support, that's what it should be: support. Home and community-based services are an alternative to institutional placement, and as such, those services are directed by the individual. They decide how much support they need, when they need it, and from whom. Let's also review the Hcbs settings rule, since it outlines more specific expectations. The rule was established by the Centers for Medicare and Medicaid Services to maximize the opportunities for individuals accessing waiver services to have access to the full benefits of community living. It was developed to ensure that individuals who are using waiver services have the same rights as individuals who do not have a disability. By creating a set of requirements for Hcbs funding, the settings rule ensures that federal funds are used for their intended purposes, and that individuals with disabilities have an opportunity to enjoy the autonomy and freedom associated with community life. The settings rule requires that home and community-based services are integrated in the greater community, support the individual's full access to the greater community, including opportunities to seek employment, work in competitive integrated settings, engage in community life, control personal resources, and receive services in the community. And to have choice about the services that they receive, who delivers those services, and to what extent. They can choose from different setting options, including non-disability specific options, to ensure an individual's right to privacy, dignity, respect, and freedom from coercion and restraint, and to optimize individual initiative, autonomy, and independence in making life choices, including daily activities, physical environments, and personal associations. and facilitate individual choice regarding services and who provides them. For Indiana to receive the necessary funds to operate our waiver services, we're required to follow the rules and regulations set by CMS for home and community-based services. And we have until March 2023, which is coming up, to come into compliance with the settings rule. If an individual agrees to receive home and community-based services, those services come with these rules that have to be followed. So if you'd like additional resources around the settings rule, feel free to contact me at jennifer.akers@fssa.in.gov. It'll be on a slide again if you need it, or contact Bequist Help or BEADS. So I am going to have Melissa Keys take over. She is the Executive Director for Indiana Disability Rights, which is our state's protection and advocacy organization. And she's going to give us some more information about what to know about decision-making supports. I'm going to be her Vanna, so she will just hit next and I will advance the slide for her. Melissa?
Hi, thank you. Really excited to be here. As Jen said, my name is Melissa Keys. I'm the Executive Director for Indiana Disability Rights. I have a master's in clinical psychology with a focus on developmental disabilities and serious mental illness, as well as a law degree with a focus on legalese and table banging. So what that really gets me is just a lot of student loan debt. Next slide. Here is my contact information. Feel free, if you have specific questions, feel free to reach out to me at any point in time. Next slide. Okay, so today we are going to cover self-determination and decision-making, looking at the guardianship role and responsibilities. And then we'll talk specifically about guardians and Hcbs. And then we're going into kind of how to address disagreements between guardians and the people that they are guardian over, as well as friction between guardians and service providers. And then we can talk about ways that you can support decision-making. Next slide. So let's start out really simple, right? We all make decisions. We make hundreds, if not thousands of decisions every day. What to eat, to wear, you know, whether to respond to that snarky email with an equally snarky email. And the decisions that we make, they really range in complexity, the time, the mental resources that we use to make them. For example, the time and energy that it takes for us to decide what we want to eat for breakfast is different than the time that it takes for us to make a bigger decision, like whether to move, whether to take a new job, what kind of car to buy. But regardless of the decision that we make, the process that we use to make that decision is still the same. It involves understanding the issue, determining the options and consequences, gathering information, evaluating the different options that we have, deciding on a course of action, communicating or implementing that choice, and then experiencing or observing the outcomes, right? Sometimes this process is instantaneous. We don't even really know that we're doing it. Other times we might be much more deliberate. We'll talk to friends and family. We'll talk to trusted professionals. We'll read Amazon product reviews. We'll do whatever we need in order for us to feel comfortable in making those informed choice. And we are empowered to make those choices and have our choices respected. And that's part of the natural human experience. That's part of what's called self-determination. Next slide. So one of the things to note is that there's a lot of different decision-making styles out there. And this is just an oversimplified version. But the point is to highlight that we all have different ways that we prefer to make decisions. We might use different tools in different settings, depending on the type of question that we're looking at. So for example, there's folks who have a more analytical style. They might make the pro-con list. They might look at data or information to try and help them make that decision. There are people who are very intuitive. I've got a gut feeling about this, or the spontaneous people, or The people who are kind of, flip a coin and we'll see what happens. There are those who are information seeking. What do the experts say? What do the online reviews say? What is good sources of information out there? And then slightly different is consensus seeking. So I'm not necessarily seeking out expert opinion, but I'm asking my trusted friends and family what their opinions are. And then there's also, passive, kind of the universe will guide me to the right decision. The decision, the result will kind of present itself. Next slide. So what we're really talking about is we're talking about self-determination, and that's the ability to have control and direction over your life. And if you think about why self-determination is important to you, why it is important for you to be able to make decisions about your own life, those are the same reasons why it's important to people with disabilities. It's the bedrock of what makes us human, and we should really try to help support and encourage someone's self-determination as possible. And there's been a growing body of research about the benefits of supporting self-determination. For example, improved psychological health, better quality of life, more community and employment positive outcomes, increased health and welfare and safety. Next slide. And on the flip side, folks who are denied self-determination report experiencing low self-esteem, passivity, feeling of inadequacy. It can have negative health impacts on physical and mental health, longevity, ability to function, reports of subjective well-being. There's a concept called learned helplessness, where if you try to make a decision or try to change the course of action, but it's not listened to or supported, that you stop engaging and making decisions at all. And so we really want to try and help support a person's self-determination to make sure that they are able to exercise that as much as possible. Next slide. So one of the things that I want to make really clear is that there are lots and lots of options to help support an adult with decision-making. There's not just guardianship. And the goal is really to start with that least restrictive option possible. That's very similar. Those of you who are in the service arena are very familiar with the concept of least restrictive environment, and that's no different for decision-making. When you think about this issue of capacity, right? Capacity is, there's a legal term of art as to whether or not somebody has capacity to contract, capacity to consent to medical treatment, capacity to enter into a power of attorney arrangement. But capacity is not a black and white yes or no issue. It really is a spectrum, and it depends on the situation. It depends on internal and external factors. It depends on the development of a person's skills. So for example, I have a driver's license. The state of Indiana has said I have the basic capacity to be able to drive a car. To do that, I did not have to know everything about how my car works. I did not have to agree to keep my car in tip-top shape and always go get the oil changed whenever it needed. It's presumed that while driving my car, I'm going to utilize the resources that I have to be able to continue to drive safely. Now, my driving skills have theoretically improved since I was 16. And so I've been able to show through practice that I can be a better driver. But even within that, my ability to drive can fluctuate depending on the circumstances that I'm presented with, right? If I'm feeling sick or under the weather, or it's raining cats and dogs outside and it's night, and my kids are screaming in the back seat, asking me to open snacks and change the radio station, is a much different driving experience than, it's Sunday afternoon, clear skies, I'm on my way to Target and Beyonce's blasting on the radio, right? Two very different experiences. But I am able to use the skills and resources that I have to make sure that I continue to be able to drive safely, right? And capacity is really no different. Capacity can fluctuate based on the decision that you have to make. Not all of us are financial experts or medical doctors. And so we have to rely on the expertise and information from others as we are deciding what to do, right? And so the important thing is we really just want to make sure that we're not seeing capacity as an all or nothing blanket situation. Somebody may have capacity in certain areas and need more support in others. They may be able to regain capacity over time if they are able to learn new skills or have additional opportunities to practice. The other thing to keep in mind when we talk about some of these different options for assisting someone with decision-making adulthood is that a lot of these can be used in combination, or they can change over time based on the person's needs. Just how we might use different decision-making tools depending on the situation, the same is true for some of these decision-making supports. So when we talk about guardianship, one of the things that we want to be clear about is it is the most restrictive option. And so when we talk about ways that we can help support a person's self-determination, we really want to try and utilize these less restrictive options first before we move on into that next higher level. Next slide. So I'm a very visual learner, so this makes sense to me. I'll try to walk you guys through it. So we're going to talk a little bit about the different levels of support that somebody can have. And again, keeping in mind that the concept of supported decision-making, of the person utilizing whatever supports or services they might need to be able to make that decision themselves, can really be used within any of these things that I'm about to talk about. So starting off, just to orient you, the least restrictive options are in that green category. The next level up are in that yellow category, and those are things where you generally need some professional assistance to get them set up or addressed. And then the final category that we'll talk about are things that a court really needs to be involved with. And so they have kind of an extra level of restriction in order to get them implemented. Next slide. So we're going to talk first about interdependence and technology. And I love this category because it really is, it can be as creative as you want it to be. These are ways to help fill the gaps in someone's needs with minimal involvement. It can be through formal services or informal, family and friends. It could be technology. It can be, you know, paper-based planners. It can be, you know, there's really all kinds of great tools out there. Next slide. There's some really interesting ways to help support people in various aspects of their life. And if you're interested, I'm happy to connect you with some of the examples that we've had. But again, creativity is the rule of the day there. For example, somebody who is having trouble budgeting their finances, having them practice through, you know, online grocery shopping, where you can see your total before you get up to the checkout lane. Having a specialized credit card that limits the amount that can be spent in a particular retail setting, so that the person still has autonomy to go out and shop, but there's a way to prevent them from spending all of their money at one particular place. There was an example of a gentleman who really liked to build model airplanes as his hobby. And so the credit card had a $50 a month limit at Hobby Lobby. So he could go, he could purchase whichever plane that he wanted to do, but there wasn't the risk that, you know, he would go and go over his budget. So there's all kinds of really unique and creative ways to help support somebody. So the next group that we're going to talk about are the supported decision-making and agency agreements. Next slide. So when we talk about less restrictive alternatives, what we mean from a legal sense in Indiana is an approach to meeting a person's needs that restricts fewer rights than with the appointment of a guardian. So it includes, but it's not limited to, supported decision-making agreement, which I'll talk about here in a second, technological assistance, appointment of a representative payee or healthcare representative, creation of a power of attorney, things like that. Next slide. So when we talk about supported decision-making in particular, supported decision-making refers to the process of supporting and accommodating an adult in the decision-making process to make, communicate, and effectuate life decisions without impeding the self-determination of the adult. What does that mean in plain language? Next slide. So what that means is when you think about accommodations, when you think about a mobility accommodation, for example, there's a lot of different ways to help support somebody who has a mobility impairment using technology or medical equipment, things like that. Supported decision-making is a way to accommodate that decision-making process that I went over at the beginning. It's where people choose and use trusted friends, family members, professionals to help them through that decision-making process in a way that they want to be supported. They retain all decision-making authority, and it's really a concept to kind of increase empowerment and self-determination. Next slide. So people often ask, okay, well, what does that look like? And it's kind of hard to give examples because for each person it might be different. But if you think about the ways that you yourself make decisions, as Jen said in the introduction, everybody is using the principles of supported decision-making anytime they use a support to help them make that decision. So if we think about those different steps in making a decision, understanding the issue. So explain to me in English, right? When we go into our doctor's office and they start talking about different drugs or treatments or surgical techniques, you know, sometimes we may need to write that stuff down and look it up later, or talk to one of our friends who's in the medical field who can help explain it if we don't get the right information from our doctor. So being able to help me better understand what issue I'm dealing with, determining those options and consequences, help me see that big picture, help me figure out what some potential consequences might be to the decision that I'm about to make. Gathering information is a big one. You know, help me figure out what questions I might need to ask when I go into my doctor's appointment, or help me figure out what are good sources of information, right? With all kinds of Facebook groups out there and Wikipedia and all kinds of stuff, like help me figure out what would be a good source for me to get the quality information to help me make my decision. Evaluating those options, you know, help me make that pro-con list, help me express my values. If you know that I have said, you know, my goal is to save for a Disney vacation, and I want to make a decision about, you know, buying a new TV when I have a perfectly functional one at home, helping me work through, is this really going to help you reach your goal to save for your Disney vacation? Next slide. And then making a choice. There's been a lot of research out there about folks with autism spectrum disorders or folks with schizophrenia who report feeling stuck when presented with needing to make a decision right in the moment. Doctor is in the room and says, what's your choice? Are you going to do A or B? And then they freeze and are unable to make a decision. So another way to help is to help the person get unstuck. You know, hey, it looks like you're having trouble. You want to go for a walk? Do you want to call the doctor later with your choice? Helping them realize that they don't have to make that decision right then. Whatever they need to help them feel unstuck. There's also research about folks who spiral when they start to feel so overwhelmed with the decision that they have to make. They start to imagine the rabbit hole of possible consequences that could happen from this one decision. So help them reframe, help them get back on looking at the question in general, right? And then communicating or implementing choice. help me express my choice. And I put a little asterisk here because if you are attempting to help them express their choice without them being present, you may need another document like a power of attorney that would give you the authority to do that. But if they are in person and say they need assistance with communication, or if they have a hard time expressing themselves in front of people whom they feel have positions of authority, help them advocate for themselves. And then observing the results. The biggest thing here is supporting the choice I've made. We've all been there where we've thought we're making the right choice, or we know we're making a not so great choice, and we've experienced the consequences, right? And the last person anybody wants to hear is, I told you so, or you shouldn't have done that, or you should have just done what I suggested. That's not a way to help support the person's choice. We all make bad choices. We all have things that happen that we didn't anticipate. So the best thing to do is to help the person understand and move on from the choice, either learning from it or helping to correct something that might need correcting. And here's just a very quick example. So my friend Jamie, who you all might know, the first person in Indiana to have her guardianship terminated in favor of supported decision-making, she moved from Richmond to Muncie and was setting up the new utilities in her apartment. And she called a company, and I'll just call it Schmomcast. And as we have all experienced in the past, was sold the premium deluxe package where you could like launch nuclear warheads from your apartment if you needed to. Like, it was way more bandwidth than what she needed. Now, Jamie is a gamer. She likes to post YouTube videos of herself playing her games. And so it was important to her that she had enough bandwidth to be able to support her hobby. And so when she got her first bill, and it was quite expensive and outside her budget, her supporters didn't say, oh, you know, Jamie, you messed up. We're going to put you back under guardianship, or we are going to now handle all of your utilities, or we are going to be in charge of this, or you can't have internet at all because you can't be held responsible for setting it up. No, they helped her understand her budget and what would meet her needs based on the different packages. They helped her understand what she needed to say when she would call the company to try and change, because anybody who has experienced that knows that that can be a very difficult conversation. And they helped her fix the problem. And yes, she had a very expensive mistake for 1 month, but she learned from that, as we all have, right? So she was able to gain those skills, keep her independence, learn from and move on in her life. Next slide. So the cool thing is, as we've talked about, anyone can really use the concept of supported decision-making. It's not restricted to just somebody with a diagnosis or a disability. It can be used within other decision-making agreements. When we talk about the formal legalized form of supported decision-making, there is allowance within the statute for even those who are under guardianship to be able to use it. So this is really a very flexible tool that can be used. Next slide. So one of the questions I also hear about is, quote unquote, people without supporters. Folks who don't have family in their lives, or whose family members are not good supporters. And so they're like, oh, well, this would be a really good concept, but they just, there's no supporters. So thinking creatively about who's involved in that person's life. What community-based activities do they enjoy that might be an opportunity to develop some meaningful relationships? Are there parents of their friends who they trust? Are there former teachers or providers that they trust? Because again, there does not have to be one overall person for everything. It can really be individualized based on the person's needs and the areas that they want to have assistance in. Next slide. So I'll talk a little bit about the supported decision-making agreements that are outlined in Indiana code. So essentially, the reason why we have the formalized supported decision-making agreements, because again, one of the questions I get is, if we all use supported decision-making already, why do we need to have this piece of paper spelling out what it is that we're going to do? Well, I wish we didn't have to have them, but unfortunately, especially for folks with disabilities, there may be providers or services that question their ability to make decisions, either based on their diagnosis or based on their history. And so having that formalized agreement allows the person to not only have some structure and reference for the tools that they might need in case they need that. It also allows the supporters to be on the same page about what their role is in that relationship. And then that document can also be used to help show the person or organization that is unsure as to whether the person's providing informed consent, that they are able to make their own decisions. They're just using accommodations in the process. Next slide. These are just some more detailed information about what the supported decision-making agreement does. There is protections for people who serve as supporters, except in cases of fraud, misrepresentation, recklessness, willful, wanton misconduct. So essentially, if you are serving as a supporter for somebody and they make a poor choice, you can't be sued for that, or they can't come after you for giving them bad advice, that type of thing. Next slide. So the next level of support that I want to talk about are agency agreements. And that is where the person has the capacity to appoint someone else to act or make decisions on their behalf. They don't require court oversight. They can be revoked by the person. And it's really, it's a good way as part of general advanced planning. And the cool thing is they can be fairly creative. They can be flexible. So for example, instead of saying, I have full and complete control over my finances, for somebody who is still gaining skills in that area, there could be an agency agreement or a power of attorney document that says, anything over $250, I am going to consult with my attorney, in fact, and have them co-sign on whatever decision I make doing that, so that you can build in protections. And then as that person gains skills, you can look at the document, you can change it, maybe put a higher monetary amount. The power of attorney documents can be used for a lot of different decision-making scenarios. And again, like I said, they're part of general advanced planning. If any of us got into an accident and weren't able to speak on our behalf, having this document to be able to say who should be able to speak for me in the event of something is just, it's good advanced planning. Next slide. So next, we're going to talk about this third category, that court category. Next slide. So within the court category, there are some tools that don't go to the point of full-blown guardianship. So for example, there are things called protective orders, where a judge can order something to happen. For example, you might see this if somebody has a settlement agreement from a car accident, or if they inherit some property that they need to dispose of quickly, if they need to get discharged from a facility, like from a nursing home into community-based care, and there's some questions about capacity, a judge can order a protective order to effectuate that scenario. There's also temporary guardianship, and we'll talk about that a little bit more, but a temporary guardianship is a way for a court to appoint a guardian for a time-limited purpose. They are not meant to be a way to jump into full-blown guardianship. It's really meant to respond to an emergency situation. For example, somebody gets into a coma and a guardian needs to step in to make sure their bills get paid or that they receive appropriate care. Not saying that it can't transition into a full-blown plenary guardianship, but it doesn't have to. So for example, once that emergency is over, the temporary guardianship can terminate and the person would retain their rights moving forward. There's also limited guardianship. Limited guardianship means that the guardian is only appointed to make decisions in certain areas. Generally, what we will see is guardianship over the person, which talks about health and where the person lives and their kind of everyday functioning, and then guardian of the estate. In other states, you might hear it called a conservatorship, and that is a guardian who oversees finances and property and assets. The thing to remember for a limited guardianship is that the person retains rights in all other areas. So when you are looking at letters of guardianship, pay very close attention to see if there are any limitations within that where the person does retain their decision-making authority. So when we talk about a guardian, it means a person who's a fiduciary. They're appointed by a court to be responsible for the person or the property of what's called in Indiana an incapacitated person, somebody who has been deemed by a court to not have the capacity to oversee their affairs. So what does that mean in plain language? Next slide. So it's a person of trust. They stand in the legal shoes of the protected person. They're responsible for the person's care. They're responsible for keeping their property and making sure that it is used either for their benefit or to the extent ordered by a court. A guardian is not automatically a representative payee. That is a separate situation, a separate process in order to get somebody appointed a representative payee. Next slide. So as I mentioned, there's a temporary guardianship that can last for 90 days. For cause, you can request an additional 90 days. And again, this would be an option if somebody might be experiencing a medical emergency or something that it may not need full-blown guardianship over time. There's limited, as I talked about, and then there's full or plenary guardianship, which is the most common type. And that's where all decisions are made by the guardian. And again, you want to look at those letters of guardianship, and letters of guardianship must be issued by a court. I can't tell you how many times I've heard from parents that they are guardians and they don't understand that that is a legal term of art. And so even though they may be involved in their child's life or they may be wanting to participate, if there's not those court stamped letters of guardianship, then they're not an official guardian. Next slide. So I want to just go over the difference between some of these options, just so you can have a frame of reference for how they differ a little bit. So this is Diana. Diana's got schizophrenia. She lives alone. She's retired. Her adult son, Greg, helps her around the house, helps her if anything major comes up, just kind of informally. So Diana slipped on some wet tile a few weeks ago. She's having terrible knee pain. Greg takes his mom to an orthopedic doctor's office to get it looked at. Doctor says, Diana, you've got a tear in a ligament in your knee. We can either do, steroid shots and physical therapy, or we can do surgery. Neither option sounds good to Diana. She's starting to experience some stress and anxiety in the doctor's office. And because of her diagnosis or her age or her behavior or the presence of her son, the doctor might begin to question her ability to consent to a course of treatment. So if we look at this scenario under supported decision-making, if Diane had her son as a supporter, she'd be able to use his support in the way that she wanted to help her make that decision. So she could have the son step in if he saw that she was feeling anxious and saying, "Hey, doc, she'll give you a call later with her decision." He could, help her research questions that she might need to ask, help her find information about, whatever might be necessary for her to feel empowered to be able to make that decision. And the process or her use of those supports, which could be written down in her supported decision-making agreement, would give the doctor peace of mind to better understand how she is making that decision and recognize her use of her son as a support as a valid way for her to legally demonstrate that informed consent. Under a power of attorney, if Diane had previously executed a healthcare representative document naming her son as either a healthcare representative or a power of attorney for medical decisions, that doctor could look to Greg to make that decision on his mom's behalf. If she didn't like it, she could appoint a new attorney, a power of attorney. She could revoke that power of attorney. She could limit it and say, he can only make decisions if I am, in a coma and unable to make that decision myself. But Greg could be a more independent decision maker, depending on the language of the power of attorney document. And then under guardianship, if a court appoints Greg to serve as guardian, then the doctor would look exclusively to Greg to make that decision. And you would hope that he would take his mom's wishes into account and advocate for what it is that she wants, but he doesn't necessarily have to. So again, supported decision-making, I make that decision myself using whatever supports I need. Power of attorney is I appoint you to make the decision on my behalf in a way that I want. And then guardianship is a court appoints somebody to make the decision, and they may or may not express my wishes. Next slide. So one of the things that I hear a lot is, we want to make sure that people are protected, right? And I get that. So I want to talk briefly about dignity of risk and this presumption of capacity. So there's not something that magically happens when you wake up on your 18th birthday where all of a sudden you're a functional adult with all of the knowledge and wisdom to allow you to navigate perfectly through the adult world, making no mistakes, right? We all learn and gain in our skills through practice, through negative experiences, and that is what's called dignity of risk. It's the ability to make decisions that result in poor consequences and being able to learn from that, right? And we have all been there. And for example, when I talked about driving, when I was in college, I was running late for class and I was low on gas, and I thought, oh, I'll fill my tank after class, not a big deal. And then after class, I was like in a rush to go home or meet friends out or something. And I went for a couple days without filling my gas tank. And then lo and behold, my car dies in the middle of the street and I block traffic and have to get it towed and have to pay the tow fee to a gas station. And, it was a really embarrassing situation. Now, the state of Indiana didn't say, oh, you made a mistake, you can no longer drive, we're taking away your license. Nor did they say you can only drive if you have more than half a tank of gas because we're worried about you losing gas again. No, I was able to learn from that mistake and move on, right? And I can guarantee you now, for the most part, I am pretty mindful when I am getting low on gas and knowing that, I need to stop. And so the same is true for folks with disabilities, but oftentimes they aren't given that opportunity to have that risk, to make mistakes. Or if they do make a mistake, there's this knee-jerk reaction of we have to protect around this, or we have to put in a risk plan to make sure that this never happens again, instead of really stopping to focus on how can we make sure that the person learns from this and has the opportunity to keep trying, right? Because none of us are perfect. We all, eat cake for dinner. We don't take our antibiotics the way we're supposed to. We don't diet and exercise the way that we should. We date the wrong people. We rack up too much credit card debt. We all do things that are not good for us. But that doesn't mean that we shouldn't maintain our ability to still make decisions over our lives. And that same concept is true for people with disabilities. Instead, we should focus on prevention through empowerment by helping people learn the skills that they need in order to be able to help make those decisions or identify toxic or abusive or exploitive behavior. Because there's no guarantee of safety under any arrangement. Having a guardian does not prevent you from, running away. It doesn't prevent you from dropping out of high school. It doesn't prevent you from eating a cookie when you shouldn't. Guardianship is just a legal mechanism to be able to effectuate certain things. So it is not a cure-all for folks who are worried about somebody making poor choices. All right, next slide. So I want to talk a little bit about getting into this section about what a guardian can and can't do, because unfortunately in Indiana, there's not a whole lot of clarity. There's certain things that a guardian must do, but then there's not a whole lot of rules or regulations about the limits or how a guardian should interact with a person that they are serving. So from a legal perspective, a guardian must act in good faith. They must protect and preserve the person's property. They should encourage self-reliance and independence. And they are in charge of considering recommendations relating to standard of support, care, education, and training. Next slide. So when we talk about what may a guardian do from a legal perspective, they can receive and dispose of property. So for example, if the person under guardianship inherits a piece of real estate, the guardian can sell the real estate on behalf of that person. They can take custody of them and establish their place of residence. They can consent to medical or professional care and treatment. And again, this is presuming that is either a full guardianship or a guardianship over the person. Again, you want to look at the letters of guardianship to see if there are any limitations. The guardian may consent to marriage. The guardian can, in certain circumstances, delegate decision-making authority to the protected person. We don't often see that though, but they do have that ability. And there is a provision, like I mentioned, within our supported decision-making code that allows somebody, even under guardianship, to utilize supported decision-making. Next slide. A guardian may pay a third party for the person's care. They can pay their debts and assets from the protected person's assets. The guardian is not themselves liable. So for example, if the protected person racks up a lot of credit card debt, the guardian is not on the hook to pay that debt themselves from their own resources. The guardian may distribute income. They can get reimbursed for reasonable expenses that are made in good faith for the benefit of the protected person. However, there should be careful to make sure that there's not intermingling or commingling of a person's funds. They can receive reasonable compensation. I believe there's a set aside amount within Medicaid to allow a guardian to seek compensation for that. They can also petition the court for compensation. Next slide. Now, these are some things that a guardian must have prior court order. However, I will say not everybody knows this necessarily. And so They may not know that they need court permission, but this is just something to keep your eyes peeled for. So the guardian must have prior court order to file for divorce or legal separation or get a marriage annulled, to consent to sterilization, to restrict voting rights. And I will say I have not, in my experience, I have not seen that. So a person under guardianship still has the ability to vote and vote independently. They need prior court order to access electronic communications or digital assets, to settle a claim or a lawsuit for the protected person to make sure that it goes to their benefit. And then moving to a new county or state, but we all know that one particularly hardly ever happens. Next slide. So there are things that a guardian should do, and these are based on the National Guardianship Association for Certified Guardians as part of their ethics and best practices. Now, these are not statutorily required in Indiana, but these are the qualities that we would hope to see in folks who are serving as guardians, especially in a professional guardianship role. Obviously, we want to see that they treat the person with dignity and respect, that they maintain privacy and confidentiality, that they involve the person in the greatest extent possible in all the decision making, that they adhere to least restrictive options when talking about restriction of rights or settings, that they advocate for the person's preferences, that they avoid conflicts of interest and self-dealing. And that's a really big issue in Indiana. I know several providers also serve as guardians, or their staff may serve as guardians in certain circumstances. So making sure that we address that conflict of interest as a way to make sure that the person is able to have a representative that is independent from the service sector. The guardian should obviously comply with all laws and court orders. And then again, no commingling of funds. And again, these are the national guardianship ethics and best practices. These are not necessarily statutorily required in Indiana, but they are, again, good qualities to have. Next slide. So I want to talk a little bit about guardian liability, and then I'll turn it over to Jen a little bit to talk about that guardianship interaction with Hcbs. So guardians are immune from civil liability for their performance as a guardian, except for things like gross misconduct. So again, if the person gets arrested for shoplifting, the guardian is not on the hook for personally being responsible for fixing that issue. A guardian may be removed by the court on petition if the guardian becomes incapacitated themselves, if they are, disqualified, unsuitable, or incapable of discharging their duties. Mismanaging assets is generally one that is a way to have a guardian removed, or if they failed to perform a duty imposed by law or court order. You don't have to be the person under guardianship to do this petition. Any interested party may submit a petition on behalf to alert the court about problematic guardianship duty. Unfortunately, Indiana does not have a court investigator program that would allow the court to, assign somebody to look into the issue. So it can become a very onerous process to try and remove a guardian. Next slide. So I'll turn it over to Jen.
Okay, part of the reason we're discussing this is because there are still some rules with the settings rule that sometimes seem like we don't know how they interact with guardianship. So we want to cover that specifically in these slides. And so Having a guardian doesn't mean that the person loses all decision-making power. They should, to the greatest extent possible, lead or direct their PCISP planning process and their team meetings. They should have choice in activities, food preferences, personal items, and friends. The person's perspectives, wishes, and goals must be addressed and considered when identifying services and living arrangements. And the thing that the guardian does have power over is that they are the ones who can change service providers, withdraw the person from services, and hopefully advocate on behalf of the person using those guardianship ethics that Melissa just went over. So this is why we're talking about this. The settings rule doesn't say that guardians still don't have powers, but it does say that if you want to use these government funds, you have to support freedom and autonomy and independence. So like all government programs, Hcbs waivers have rules that have to be followed, that providers have to follow. And so that's why we're talking about this, because guardians have to allow a certain level of independence under the waiver program. They can't use the waiver and Medicaid funds to enforce their preferences and their beliefs. They have to really be based in the things Melissa is talking about. So under home and community-based services, recipients have certain rights. And we've talked about this in some of the previous trainings about honoring rights and in my review of the settings rule and the waiver rules. So individuals have the right to be treated with respect and dignity, the right to have relationships, to see information about themselves and to keep their information private, to be in charge of their meetings and services, to have materials available and explained to them so that they're in a way that they can understand, to be free from abuse, neglect, and exploitation, to go to the doctor, dentist, hospital if needed, to make a complaint without fear that something bad's going to happen or they're going to get in trouble and there'll be some sort of negative consequence, and to be in charge of their belongings and money to the greatest extent possible. They also have a right to have a lease or similar documents with protections equal to those under Indiana's landlord-tenant laws, to have privacy in their sleeping or living unit, that their units have entrance doors lockable by the person with only them and appropriate staff that they have designated to have keys, to have a choice of roommates if they're sharing an apartment or a home, to furnish and decorate their sleeping or living units within the terms of the lease, freedom and support to control their own schedules and activities, access to food at any time, and to have visitors of their choosing at any time. If you're familiar with the settings rules, these are specific to provider-owned and controlled settings. And so these things need to be in place unless there's a reason that some of these right here rights need to be restricted. When you're talking about modifications of individuals' rights, it's not allowable for everything. Like you can't say this individual, I don't believe that they need to be protected from abuse, neglect, and exploitation. That's a basic right that cannot be modified. So only certain rights can be modified. And when they are modified, they have to be consistent with the settings rule. They have to be narrowly tailored and justified based on the health or safety risk for the individual, not just because of the guardian's preference, value, or convenience. And they have to be clearly documented in the PCISP or the BSP, reviewed regularly. The person has to give informed consent, which is a huge part of this. They are the service recipient, so it needs to be explained to them in a way that they understand. And then they have to give consent for the restriction of their rights. And there should be goals working towards ways to lessen or eliminate the need for the restriction in the first place, which is really our primary role as providers, is to teach them the skills to mitigate risks, but to honor dignity of risk and to make sure that we're following the settings rule. So guardian decisions that impair or prevent full compliance with the settings requirements may result in an inability to use Medicaid funds. So providers need to educate guardians. We're trying to do that through this training as well, to make sure that they understand, again, that this is a government program that has rules if you want to access Medicaid funding. So this sometimes becomes a point of contention. We recognize that. We are respectful of guardians. We understand that they have a very important role often in the individual's life. But to be proactive would be good, to have a policy for guardian involvement so that they understand, again, educating them about the settings rule and about waiver rules and making sure that they understand that. Figure out if it's something that the guardian even needs to be involved with. If it's not a legal decision, if it's something like what jeans they want to wear, they want to dye their hair, if they have the money to do that, those types of things are not necessarily things that need to even be approved by a guardian if you look at the powers that they have. If the guardian says no, don't stop there. Ask them, what is your concern? And try and work with them about what the root cause is and what are the skills maybe that they need to learn. What are the skills that need to be taught? That's our primary role as providers. Is it concerned to a legitimate health and safety issue, or is it simply a preference that they have? And can it be addressed in a less restrictive way? You can use supported decision-making, as Melissa has said, all the time, even with guardianship. It's difficult to make good decisions if you're never given the opportunity to practice and to fail and to learn from your failures. So it's important that they have choice and that they have the ability to practice that. Make sure that they understand the potential outcomes. That's where you can do some of that risk mitigation and figure out what the consequences are and what might happen, and that they understand that. And I know I'm supposed to be on a diet. I know I'm not supposed to be eating the stuff that I'm eating. I know I'm supposed to exercise more. I know from my doctor what the potential outcomes are. I still make bad decisions. We all do. So this isn't unique to any particular population. Melissa's going to talk about some more formal options as well.
Yeah. So another thing, just to piggyback on what Jen said, is if a guardian is adamant about a certain restriction of rights that is not based on the health or safety needs, legitimate health and safety needs, make sure you're very clear about the potential outcomes. This could mean that we cannot be your service provider. If we can't bill for this service, there may be an outcome of, we can no longer provide that type of service to you. So again, if you're having disagreements with guardians, it can be helpful to call a team meeting and consider involving the ombudsman. You can also contact IDR. We may be able to have an advocate also attend. Contact the court if the guardian is doing something that might jeopardize the health or their safety, or they're not acting in the person's best interest, or if they're unnecessarily restricting the person's rights without a particular need. As I mentioned, anybody who is a quote unquote interested party can submit something to the court about a problem that the guardian's not doing, and the court can order a guardian to do or not do something. And then if the person doesn't need a guardian, or if they no longer want one, contact IDR. We might be able to help them terminate their guardianship if appropriate. Next slide. So the guardians do have some authority to enforce. So if a third party, like a provider, fails to comply with a guardian's demand within the scope of the guardian's authority, so again, look at those letters of guardianship, the guardian may bring an enforcement proceeding in the court to compel compliance. A court may award attorney's fees if the person who denied the guardian's demand acted in bad faith, or if they fail to comply with the guardian's written demand or refuse to respond, that type of thing. I have not seen this so much, but it is an option. Next slide. So when we talk about policy language that might be good as a preventative measure, as a way to set the stage for the relationship with the guardian moving forward, here is some language. You don't have to use it, but it could be a place to start. And it just kind of spells out, the provider's principle and values. we want to respect personal choice and support self-determination. And we are also obligated to follow these Medicaid rules and regulations, including respecting the rights of the people we serve. And so, saying you as guardian, you agree that the person has autonomy over, day-to-day choices, or you agree that any restriction of a person's rights must be done in compliance with Hcbs rules and regulations, just so everybody is clear from the outset how that will look moving forward. And I tell you, one of the things, we hear, well, if I enforce this, they'll just withdraw from services and go down the street. Well, if all of the providers, as they should be, are following the Hcbs rules in both spirit, principle, and practice, then it shouldn't matter if they go down the street to a different provider. That provider should also have that same policy and enforcement, right? So that takes away that threat that a guardian might make for withdrawing from services as a way to try and justify rights restrictions. Next slide. So what are some ways that you as providers can help with decision-making? One is to set that expectation for self-determination as a value, as a priority, and make sure that it's communicated to all staff, and make sure that staff know how to support the person, whether or not they have a guardian, whether or not they have a formalized supported decision-making agreement. Building in decision-making as part of that get to know the person process, right? Just as you would explain and train on risk plans and service goals, make sure that you include a component about, how do you like to make decisions? How can we help support you to make decisions, right? If the person doesn't have a guardian, help them keep it that way. A guardian should really be that last-ditch effort if the person is truly unable to have the capacity to manage their self or their assets. As we talked about, there are many, many ways to help structure supports for a person that doesn't involve jumping to guardianship. That can be very, very difficult to get out of. Because again, the only two ways to get out of a guardianship is the person under guardianship passes away. A guardianship does not automatically terminate when the guardian passes away. Or you have to show a court by clear and convincing evidence that the person no longer meets that definition of incapacitated, or that a guardianship is no longer appropriate. So it can be a fairly lengthy and time-consuming and resource-intensive process to get somebody out from a guardianship that is no longer necessary, even in circumstances where the guardian is on board with terminating the guardianship. It can still be quite an onerous process. And then if you or your organization serves as a guardian, consider working towards a less restrictive option, or make sure that you are adhering to those higher standards and best practices in your interactions with the folks that you serve, and help make sure that they have as much self-determination and independence in their decision-making as possible. Next slide. Help people identify how they like to make decisions. We are not born knowing how to make good decisions, right? And so oftentimes folks with disabilities haven't had the opportunity or the skill development to figure out how they like to make decisions. And so help them identify, help them figure out how they like to make decisions, and help them learn how they can advocate for getting those supports. Help them figure out who might be good supporters in their life. Again, if they don't have a regular family member or friend that's involved in their life, help them think creatively. A neighbor who might help them with tasks that they need to know about around the house, or a friend's parent that they trust, or a former teacher, something. Help them figure out who might be good supporters in their life. Talk to them about the options that they have to get the support that they need, so that they don't feel that, oh, if I can't make this decision 100% on my own, I must, need a guardianship. So help them talk about what other ways they can get that support. Encourage meaningful opportunities for decision-making and participation, whether as formal service-related goals or just in everyday interactions. There are millions and millions of opportunities to make decisions throughout the day with varying levels of complexity. So help support the person through it. And then respect their dignity of risk. If they make a mistake, if something bad happens, help them through that process as well. And don't just jump to necessarily needing to restrict the person from engaging in that again. And then, be a supporter. In Indiana law, there, quote unquote, supporters are not allowed to be paid for their role as a supporter. But as we have talked about, being a supporter can be informal as well. So help the person. If you see them struggling with making a decision, help walk them through that process or help them figure out how they can still manage to make that decision themselves. Next slide. And I think we've left some time for questions.
Yeah. I want to thank Melissa so much for her time and for her expertise. I just have a few little closing slides and we'll get to the questions. We want to make sure that we're supporting you to make sure that all people are empowered to live, love, learn, work, play, and pursue their dreams. So that is part of why we've had this topic. If there are other things we can do to support you, please let us know. Here are some resources that we use to pull together this presentation. Indiana Disability Rights has a whole section on supported decision-making if you want more information. Charting the Life course has tools. And also, as far as the settings rule, there is a page for that as well within the DDARS website. If you'd like a resource for finding the right decision-making supports and guardianship and kind of an online training that goes into that into more depth, this might be one that you want to use. It's also for professionals as well. And so that's available to you. If you need additional information, please contact us. You can, the bequest.help email is still active, but you can also now use beads.help@fssa.in.gov. You can reach out to Indiana Disability Rights. You can reach out to the Ombudsman. You can reach out to Beads. You can reach out to me if it's a specific training or you're trying to find some of these resources. I've been asked to make sure that you're signed up for the DDARS listserv so that you're getting all of these announcements about the trainings and when the recordings and different things are available. Beads is also on Facebook, so you can follow their page to get that same information and some additional resources. The next training will be in September. It will be on September 1st and 20th with the recording being used on the 28th, but still live Q&A. We're following a regular set schedule now for the trainings. I think the next topic is supposed to be a deep dive into modifications and restrictions of rights. We keep talking about that process, but we want to make sure that you understand it in depth. That may change, so just look for a DDARS announcement in August with the information on how to register, but I just wanted to remind you that we're on a set schedule now. Thank you for joining us. We appreciate your time and your willingness to learn and understand these different regulations and rules that we have within waiver services. And I think we have some time for questions. If they're really specific, we may need to follow up with you, but Heather's going to go through some of the ones that we need to address.
Yeah, so we just have a couple of minutes left, but we have had a lot of really great questions. So just know that, this is a topic that we get lots of questions about, and there are lots of, this is an area that is very difficult to navigate. And so we understand that. And so that is one of the reasons why we have brought Melissa in to kind of help answer some of those questions. And we will continue to work to provide resources and more information, to help all case managers and providers kind of navigate these waters. So with that being said, Melissa, there are a couple of questions here around if you can elaborate around electronics and communications. And so like if an individual has, a computer or a phone or, those types of things, does the guardian have to have, a court order to access those things? Do they have the ability to restrict access to those, to restrict access to the internet? Just, around electronics and communications, what is the guardian's ability to restrict access to any of those types of things?
Yeah, so the Indiana statute speaks to a guardian needing court approval to be able to access a person's digital communication. So that would be things like email, their phone, text messages, that type of thing. And so technically they would need to have specific permission from the court. It would either be spelled out in those letters of guardianship or it might be a separate statement. When you talk about things like restricting access to the internet, that again would be something that you would look at as a restriction of rights. Is that related to any specific health or safety need, or is this more the preference or fear from the guardian that something bad is going to happen? So again, you really want to take a good look at those letters of guardianship. And again, a lot of them are fairly generic. But if this is not a legal decision, then it's really not something that a guardian necessarily has the authority to do. I want to talk briefly about non-responsive guardians, because I know that comes up a lot, is the providers trying to track down and get approval from a guardian. The first thing you want to do is ask if this is really something that the guardian needs to legally approve. Is this a legal question? If it's not, then talk to the person, help them work through what it is that needs to be approved or not approved, and move on. If it is a legal issue, and the guardian is not responding, especially if there's an emergency, you can alert the court. If it's a medical emergency, there's ways that the hospital or medical provider has to operate in order to be able to make decisions when a decision maker is not available. And so there are different ways that you can address that depending on the issue. Hopefully that kind of helps clarify.
Yes, thank you. There are some questions around finances, and there's a really good question around if an agency is a rep payee, but they also have a guardian, what is the guardian's role in making decisions about the individual's finances? And so does the guardian still have the ability to dictate how the individual spends their money? So for example, if the individual wants to purchase the Xbox, can the guardian say no? Or is it really, because the rep payee is in charge of their money, is it really the rep payee's decision?
So, and again, it depends on, most courts don't really do very detailed letters of guardianship. And so it's unlikely that something would be spelled out specifically within the letters of guardianship of like, you can only make decisions about blah, blah, blah. And so the representative payee is in charge of making sure that the person's Social Security benefits are used for the beneficiaries' benefit and support. And so when it comes to purchasing those extras, and again, this might be something where we might need a team meeting. Okay, the person has said that they have as a goal, they want to purchase an Xbox. Well, let's have them look at their budget. Do they have enough money to do that? Do they, is this something that they may need to save for a couple months to be able to do? Because again, restricting somebody's ability to purchase something using their own funds, absent a health or safety reason for that, would to me be an unnecessary restriction that a guardian shouldn't be able to do. Now, if the person says, I am going to take my entire Social Security check for the month and spend it on this Xbox, the representative payee's role is to make sure that the person's bills get paid and that their needs are met, and then whatever they get their whatever's left over at the end, or their minimum allowance, to be able to spend however they see fit, and they can spend it however they see fit.
Great. So there's another question around if there are guardians in place and there's no plan in place for when they pass away, is there a way to void guardianship or to put something else in place without having to go to court?
Is that when the guardian passes away?
Yes, yes.
Okay. Yeah. So typically, or what you would hope to see is there might be a successor guardian named, especially if the current guardian is aging. So if there is a successor guardian, generally you just need to notify the court, and the court can issue new letters of guardianship. So if there is a co-guardian, again, depending on what those letters of guardianship say, the co-guardian could step in. Otherwise, the court really needs to be alerted when the guardian dies. If the person does not have somebody else that can stand in the role of guardian, but guardian is truly the restrictive setting that they, or the restrictive tool that they need, then the court can work on appointing a professional guardian or a VASIA if there's a VASIA program in the state, and those are the volunteer advocates. But again, and I've heard examples of this where the guardian dies and the person's just operating for like 4 or 5 years, then I would really strongly question the need for a guardianship moving forward.
Okay. Another question is, what is the responsibility of a guardian regarding child rearing or the expenses of child rearing if the person who they are guardian for has an unplanned or even planned pregnancy?
So the guardian is not personally liable for expenses related to childcare, but just as they would anything else, they would be, if there are expenses that the person has related to their child, the guardian would have to, work on approving those. Depending on, and this is again where Indiana code is a little bit funky. So the parents' rights to consent to things like medical treatment for their child, I am not aware, and I'll have to do some checking to see, but in certain circumstances, the parent can sign consents for their child, even if they themselves are under guardianship. It really it can be dependent on the circumstances, and I'd be happy to do a little bit more research into that to see if there's any clearer guidance in Indiana.
Okay. Here's an interesting question. Do guardians, if the individual lives on their own, but they do have a guardian, do guardians have the right to intercept their mail?
It depends. So again, the guardian stands in the legal shoes. And if the guardian is, quote unquote, intercepting the mail as a way to make sure that bills aren't lost because the guardian is responsible for helping to make sure they get paid, then that's one thing. If it is, I'm going to open all your mail and not give you access to letters from friends or family, then that, to me, is a step too far. So again, it really depends. If the person, has a history of like throwing away all the mail and the guardian is doing it as a way to make sure that they don't miss important notices, that's, that I could see as an appropriate guardian authority. But if it's just to keep the person from getting their personal mail, then I would think that would be an unnecessary rights restriction.
Okay, great. Well, I noticed we are right at 11:30, and so to be respectful of everyone's time, we still have quite a bit of questions. And so I think what we will do is, I know we'll have a lot of questions the next two sessions as well. And so I think we will, in partnership with Melissa, use all the questions that you guys give us, and we'll develop some type of FAQ to go along with these trainings. So and know that Melissa, has graciously offered to be a point of reference for all of you. And of course, you can reach out to us at Beads, and you can reach out to Jennifer as well. So we want to thank you all for joining us today. And thank you, Melissa, for spending your morning with us. And thank you, Jennifer, for doing a wonderful job again and sharing your story.
I just wanted to say one more thing. If you're still with us, you should get an email from Zoom tomorrow that will have a confirmation that you attended. So that can be used as the certificate of participation that you were here. The state does not need to see that in any way because they get the attendance from Zoom. I send that to them, so they will have a record of your attendance. But if you need it for your case management company or something, that confirmation should serve that way. And again, the recording and different information should be available in early August. So thank you so much for joining us. Have a great day.